Good evening, everyone. Welcome to Quadrant House. And as your chairman, I ought to thank LSLC for sponsoring this evening and Quadrant Chambers for hosting us. We are concerned this evening with a very interesting niche but increasingly important issue of how to deal with hedging in terms of damages for breach of contract. It's a bit of a niche issue at the moment, but it's of increasing importance as the practice of hedging becomes used more and more widely in business as a way of limiting risk. And of course, there is hardly a case concerning contract which doesn't somewhere or other involve the question of damages for breach thereof, if indeed a breach is found. So it is a new area of increasing importance, and I have to say that I'm very grateful to the slides which have been presented to me for your edification this evening, which have taught me a great deal that I didn't know. So you are in for a treat. I'm surrounded by a very distinguished tribunal made up of Catherine Jago on my extreme right, who is a very well-known expert in the field of oil and gas trading, Chirag Korea and Paul Toms from Quadrant Chambers, KCs at the top of their form, and Robert Gay, a full-time arbitrator who has been both a barrister and a solicitor in his time, and may even, under current rules, about which I know absolutely nothing, be both at one and the same time to this day, but I know not. Anyway, we're going to operate in the following way. Catherine Jago is going to introduce the subject by telling us what traders do and why they do it. So that will set the scene. Then we're going to have Chirag Korea, who is going to review the jurisprudence, all I think at first instance, up to but not including the most recent and only Court of Appeal decision on the subject decided in June of this year, Rhine shipping, otherwise known as the DJLA. Then Paul Toms is going to take us into Rhine shipping and explain all that to us. And then Catherine Jago is going to come back and with the learning which has been introduced, the jurisprudential learning which has been introduced, is going to tell us something about what business people think about it, which will be very interesting. And then Robert Gay is going to wrap up by and he's going to give us the final award. He's going to give us the arbitrator's overall view of the thing. So we're going to begin with Catherine.
Thank you very much, Sir Bernard. Thank you very much for inviting me here this evening for a topic that's very close to my heart. And in a way, I somewhat despair, Sir Bernard, when you say that this is a new and growing area, because I started in this business as an expert 35 years ago, and I've been talking about the impact of hedging on damages since then. But it's taken a long time, partly because there have been so few cases that have actually been heard in the High Court. There are a lot of cases in arbitration, and of the work that I do, a good 60 to 70% of my cases involve hedging, but a lot of them are either decided in arbitration or they settle. So I'd like to just take you through a few of the basics, and let me get to the first slide. Oh, I do like to show you that slide, which I think is very appropriate, and is perhaps the way that a lot of people think of traders as sharks hiding under their hedging. But there you go. That's a little bit about my background. So the first thing to remember is that no trader is going to hedge unless they've got a price risk. So if a trader buys at a fixed price and sells at a fixed price, they don't have a price risk. They've locked in their profit. And hedging is really all about trying to lock in your margin. The problem is that most trades are not done at fixed price, they're done at a floating price. So you may buy at a floating price and sell at a floating price. Now, if those two floating prices exactly match, so they're the same benchmark, same price timing, you've still not got a risk. You've bought it at, say, the average of 5 days of Platts after bill of lading, plus $3, and you've sold it at the average of Platts 5 days after bill of lading at $10, and you've made your profit there. So again, you're not going to hedge. The difficulty comes when you've perhaps bought it fixed price, or it has priced already because it's priced around loading, but the cargo hasn't sold at a fixed price yet because it's being sold around delivery, 5 days after NOR. That's when the price risk exists. Now, I will go back on what I've said, because what we are concerned about here is what happens when breaches occur. And you may not have a price risk when you do your trades, they may match, but if this trade suddenly falls away because there's been a delay or because the cargo is contaminated, your buyer won't take it anymore, you've bought it fixed price, suddenly you're exposed to the market. So that's when you might need to hedge. So the first thing that any trader must do is to look at what their price risk is. And then they look at how they can manage that price risk. And they can do that either internally or externally. Internally means that they try to match up their price risk on one contract with an equal and opposite price risk that they've already got in their position. So, for example, they may be long 700,000 barrels of crude oil for delivery in May, or pricing in May, and they may be short 700,000 barrels of crude oil pricing in May. They can match those up. They don't need to go into the external market to hedge. But I would contend they are still protected, because whether or not it's internal or external hedging, the objective is exactly the same: to manage the price risk and to hopefully reduce it. The price risk is something that they want to manage if they have no idea what the difference is between the two. So if you've got it, you've bought it floating price over a particular number of days around loading and sold it at a price around delivery, you don't know what's going to happen between those two times. Traders don't like that uncertainty. They like to know that they can lock in their profit. And neither do the banks like that uncertainty. And that's why most traders will hedge. And it is very common for traders to hedge now, and very few don't hedge. So that is price risk. And I should caveat everything that I'm saying. I'm not hoping that you're going to go away at the end of this and start hedging, all right? That is not the expectation. All I'm trying to do is to lay down a few ground rules so that you can understand the implications here. But if anybody wants to have further discussions about this, I'm very happy to do so, either later on this evening or on another opportunity. So we've established we've got a price risk. What is hedging about? Well, hedging is simply a term used by commodity traders, because although we're talking about oil, hedging is used for other commodities as well. The most basic concept of hedging is, and I've quoted it here, a trader takes an equal but opposite risk position to the physical price risk they face by using a derivative. And that derivative is a trade that uses generally paper barrels. In other words, not physical oil, they're paper barrels. And its value for those paper barrels is derived from the price of the physical oil. So let's go back to my example of a crude cargo. You may have a cargo of Fortis crude. No, actually, let's not use, well, we could use Fortis. Let's use a Nigerian crude. So let's say we've got a cargo of Bonny crude. And Bonny crude trades at a differential to Brent, dated Brent. There's no derivative for Bonny crude oil. So what a trader would do, they go into the market and hedge using a Brent derivative. and they would use that to hedge their price risk between their purchase and their sale. Now, of course, what you ideally want is that the two will exactly match. Your physical oil will move price-wise in the same way as your hedge. It's never perfect, and I won't go into the reasons why it's never perfect. And so it rarely covers 100% of the price risk, and at best it usually covers somewhere 80 to 90%. And the essence, the idea is that if your physical oil price moves down, your hedge will move for you. So your physical oil price is moving against you, your hedge will move for you. What you lose on your physical, you gain on your hedge. Let's take an example. So you've bought a cargo, you're looking to sell it. What you're fearful of is that by the time your sale prices, the market will have fallen. So what you want to do is to sell a hedge. You sell it as soon as you recognize the price risk. The market falls, you get less for your physical, but you've sold your hedge up here, you can buy it down there, you make the profit, and hopefully that will compensate you for the differential that you've lost on the physical. As I say, it doesn't always work like that. So the essence of this particular case is about the difference between internal and external hedging. And I would say that they are the same. I say that there is no difference between the two. And who does external and who does internal hedging? Well, big companies will have lots of positions on their books. There is a cost associated with hedging. You have to pay to take out these transactions. So if you've got length and you've got short and you can match them, it makes sense to do that internally. You balance it out, and then anything that's left over. So say, in simple terms, you're long 1 million barrels, but you're short 700,000 barrels. Your net difference is 300,000 barrels. You can either keep that as a speculative position, or you can go into the external market and you can hedge those 300,000 barrels. And that's going to cost you a lot less than going to the market and hedging the 1 million barrels and hedging the 700,000 barrels. So that's why people do it. But that's a luxury, if you like, that smaller traders can't do because they don't have the big books. So they have to go out into the market and trade individually. So the other point that I want to make is that speculative hedging is very different. In fact, it's not hedging, it's speculative trading. And it's important to understand that hedging should reduce your risk. That's the objective of hedging. It's not to create more risk. So somebody who doesn't hedge is actually speculating. They're speculating, taking the example that I gave before. The market's here. They've sold their cargo at a floating price sometime in the future. They actually don't know whether it's going to be down here or up here. But if they don't hedge, they're speculating that the market will go up here. And if it doesn't, they're going to lose that money. So it's much more risky not to hedge.
Do you want a time guide?
Well, actually, that's as far as I was going to go at this stage. I hope I haven't lost you all.
That's it.
I was going to pass on to Shoaib to now talk a little bit about the cases up until Rhine shipping.
Thank you very much, Catherine, and good evening, everyone. Thank you for coming to Quadrant Chambers and to the LSLC seminar. As Sir Bernard said, I'm the prelude, the warm-up act, as it were, to Paul Tom's.
Thank you very much. Thank you.
My job is to build a pedestal upon which Paul Toms is going to stand. So, but it is important at least to see the lay of the land prior to the latest decision by the Court of Appeal. So what I'm going to do is, first of all, point out some very basic principles, particularly in relation to sale of goods, because we're talking generally about traders, but you'll see that we have some cases involving charter parties as well. And just to remind everyone, the non-acceptance measure of damages under the Sale of Goods Act, Section 50, subsection 3 is the contract minus the market. The non-delivery is market versus minus contract. And of course, breach of warranty is value as warranted minus the value as delivered. And as we know from the Golden Victory, for example, that you take the price not necessarily immediately after the breach, but a reasonable period after the breach, allowing for the innocent party to go back into the market. And the question is, where do hedging losses or gains fall into this? So the first case to consider this, albeit very much obiter, was the decision of Morrison J in ADAX versus Arcadia Petroleum in 2000. Now, that was a claim by the seller for damages against the buyer for late loading of a cargo, FOB. Now, the delay, as the result of the delayed lifting of the cargo, the difference between the value of the cargo if it had been lifted on the day that it should have been and the day that it was $962,000. Now, the seller, ADAX, had breached its position, and as a result of its had hedged its position, and as a result of its hedging, its losses had been reduced to $816,000. Now, the buyer, the breaching buyer, made the very optimistic argument that the seller should get nothing because the seller should have sold back to back. And if the seller had sold back to back, then there would have been no price risk at all. Of course, the court wasn't having any of that. Mr. Justice Morrison decided that the standard sale of goods measure applied, and the seller was entitled to the full difference between the value or the price he would have got if it had been lifted on time and the price that he did get being 962, but then awarded 816 on the basis that that's all that ADAX had claimed for. So that was the end of the case. Obiter, however, he said if he was wrong on all of that, he would have awarded the seller $816,000 because, as between traders, it was reasonably foreseeable that the seller would have hedged in the way that the seller did, and hence would have suffered the type of loss that he did suffer as a result of the delayed lifting. So that's usually the first port of call, albeit it was very much obiter. The second case is one which I was involved in, called the MSC Amsterdam, and this comes in a very different context. What had happened here is there'd been a misdelivery of, I think it was 18 containers of copper cathode in Shanghai. Now, the copper cathodes actually weren't stolen. They still remained in Shanghai customs, but because they were cleared by use of a fraudulent bill, they were essentially stuck there for the foreseeable future. The bill of lading holder, Trafigura, had hedged its price because it was long and hadn't yet sold on. And given that the cargo was apparently stuck in Shanghai, it had to keep those hedges open. So they had to roll them over. And that incurred additional rollover costs, but it also meant that they had the risk of those hedges being underwater. Now, that wasn't a problem as long as they were able to get the cargo at the end of the day. So if they were able to get the cargo at the end of the day, as Catherine explained, the loss or gain on the physical cargo should be offset by the equal and opposite loss and gain on the hedge. But here what happened is by the time we got to judgment, the cargo was still stuck in Shanghai and therefore was deemed to have been lost. And one basis upon which Trafigura quantified its loss was to say, this is our hedging loss. This is the loss that we've made, because the copper cathode's physical price had actually gone up. And we had evidence as to what a container operator would foresee. And we were able to persuade Mr. Justice Aikens that this was not a foreseeable type of loss from the perspective of a container operator, albeit it may well be from the perspective of another trader. Now, as it happened, they got most of the damages they wanted by a different mechanism, but the claim for hedging losses failed for remoteness. We then have the Namada spirit, and this was a buyer's claim against the seller for repudiatory breach, non-delivery of crude oil. The buyer had hedged upon purchase and closed out when it accepted the repudiatory breach. As a result of the early closing of the hedge, the buyer's hedging losses reduced his total loss by 2.5 million. And the question was this hedging gain to be brought into account? I say gain in quotes because what had happened is if the contract had been performed, the hedging loss would have been even greater than it was. So there was a hedging loss, but it was a relative gain compared to the no breach situation. And it was argued, well, this is just like insurance, right? It's res inter alios acta. This is something that we took out to protect ourselves. Why should the breaching party get the benefit of that? And Mr. Justice Blair held, no, that's not correct. What the seller did, was in the normal course of its business, when it closed out the hedges, once the contract was terminated, that was an act of mitigation. And the gain that was accruing to the seller as a result of that act of mitigation failed to be taken into account. The third case is Choil versus Sahara, another one in which I was involved, and that was a claim by the buyer who I represented against the seller for delivery of contaminated naphtha. Now what happened is the naphtha was loaded, the vessel went off, buyer was very happy because not only had he bought, but it had actually on-sold. So it had no price risk, as Catherine was explaining. Then the testing results started to come through, and the buyer, the sub-buyer, shall we call it, pulled out and said, I'm rejecting the cargo, this is off spec, I'm not going to buy it. So suddenly, my client found itself long on naphtha. It then went in and sold some Brent futures so that it could take out some price risks. Ultimately, it was able to sell this contaminated naphtha for $1.5 million more than the price it would have received for sound naphtha under its original on sale. And so when we appeared before Mr. Justice Christopher Clark, he says, well, what are you complaining about? He says, yes, that sounds really good. But we opened up a hedge and look at the hedge losses, and it was, I think, over about 2.5 million. So you have to bring the hedging losses in as well. And again, we had some expert evidence and the traders, and indeed both sides traders said that they do hedge. The evidence was that my clients not only did hedge, but were required to hedge by its bank. Yeah. The bank would not permit it not to simply speculate. So the hedging losses were held to be recoverable as foreseeable. Mr. Justice Christopher Clark also held that hedging losses were not consequential or indirect losses, so as to fall within one of the exception clauses in the contract, because they were something that would be foreseeable to both parties as the ordinary way of doing business, given that they were both traders. So that's Choil. The Rowan is a slightly different. It was a charterer's claim for breach of charter for a vessel's loss of Shell approval. The charterers, therefore, as a result, lost their sale to Shell due to loss of approval. The owners argued that the charterers had failed to mitigate by failing to hedge their open position after loss of the sale contract. So this was a failure to mitigate argument advanced by a ship owner against a charterer. The argument was rejected. The court held that the obligation to mitigate is not a heavy one. There was no direct hedge available. There was a crack spread, but it was speculative and inappropriate. So in that case, they held that there was no failure to mitigate. Query whether on different facts, where hedging was clearly the obvious thing to do, whether the breaching party could make out a case for failure to mitigate, although that's, in my experience, and I'm sure in judicial experience here, always very difficult to do. So concluded remarks. When does hedging come into play? Comes into play, as Catherine has explained, where you have pricing risk because you're either long or short. What is the legal test for recovery? Certainly at the time of these cases, it was asking whether the remoteness test in Hadley and Baxendale is satisfied, what evidence is required. You may need expert evidence as to what parties within that trade, or what a reasonable defendant in the defendant's trade in the MSC Amsterdam, for example, a container operator would reasonably have foreseen. Differences between differing trades, well, yes, you see that from the MSC Amsterdam. What you expect a trader to foresee is very different from what you expect a container operator to foresee. Therefore, the sophistication, or the reasonably anticipated sophistication of the defendant, is relevant. And if the parties are not in the same trade, then things become a little bit more difficult. So I hope with that I have built the relevant pedestal for Paul.
Thank you, Chirag. So I'm going to be talking about the case Rhine Shipping and Vitol. I want to explain to you the facts. You've already had a really helpful outline of what internal hedging is. I'm just going to put some of the detail of the internal hedging that was in play in that case to you. I'm then going to explain to you what the arguments were at first instance and before the Court of Appeal, and obviously tell you what the outcome was. So this was a case where Vitol had purchased crude from Total. And as Catherine's already indicated, the purchase price was not fixed. It was calculated by reference to a benchmark, and it was to be priced based on an average of 5 quotations after the bill of lading date, so sometime in advance of the contract. Vitol chartered the vessel, the De Gila, from Rhine Shipping for the purpose of taking delivery of the cargo from Total at the load port and for onward carriage. By reason of matters which the court held were breaches of charter party by Rhine or gave rise to an indemnity, the vessel was delayed in arriving at the load port and therefore taking delivery of the Total cargo. That meant that Vitol had to pay $3.7 million more than they would have done had there been no delay and had there been no breach. Vitol therefore claimed that sum as damages, being the loss on the physical trade. So the defence that was raised by Rhine Shipping was that that loss on the physical trade had largely been avoided by reason of the performance of the internal hedges that the Vitol had. Those hedges had been booked in what Vitol referred to as its internal risk management system, which was called Vista, and had been done shortly after the conclusion of the physical trade. Later on, when it became apparent that by reason of the breach there was going to be delay in loading, which was going to delay the pricing under that contract, those hedges were rolled internally. In other words, they were varied so that the new pricing dates were covered. The outcome of that was that if you were to look in that system, you would see associated with the physical trade a gain on those internal hedges having been rolled in the amount of about $2.8 million. So what Rhine Shipping argued, therefore, was that Vitol was not entitled to 3.7. The 2.8 million hedging gain had to be netted off, resulting in a claim of the order of $900,000. So let me just give a bit more detail about how the system operated. This is all covered in the evidence and subject to findings of fact at first instance. So once a physical purchase contract was grouped with a physical sale contract, Vitol would want to understand the market or pricing risk, just as Catherine has outlined, which would be inherent in those groups of transactions. And ultimately, they would wish to understand the net pricing risk to which it was exposed across the entirety of its trading operations. So as part of that process, it would enter in its system, its risk management system, Vista, a notional purchase, on the facts of our case, of a swap, a hedge, reflecting the terms and pricing that would have applied had they gone into the market and externally hedged. That swap would be booked in Vista alongside all other transactions relating to any individual physical trade. What that would then do automatically is generate the sale side of the swap somewhere else within the system. And it would be located in a portfolio of paper risks, which were derived ultimately from other physical trades. And that portfolio would be the seller of the swap, and in effect would be the proxy for the original pricing risk on the physical trade. So to try and encapsulate that more briefly, you have a physical trade, you put into your system what you would do if it was external. That would then automatically generate a counterpart to that internal sale contract of swap, and that would be grouped with other paper trades derived from other physical transactions. So once that's been done, in order to understand the net overall exposure for any particular pricing risk, Vitol would look to see, in effect, if those pricing risks could be offset. Could you find an equal and opposite pricing risk? And the evidence at trial was to the effect that if you could, it was almost certainly derived from more than one physical trade, and it might even be you chop a bit of a pricing risk from one contract, another bit over there, and even on the other side of it, it might be a group of consolidated partial pricing risk. But in broad terms, what you're trying to do is to look somewhere over here and find one pricing risk, and somewhere over there an equal and opposite one. That's done on one level, then it's done across other levels. And once it's been done, Vitol knows now whether it is long or short on a net basis, and then it can decide whether it wishes to leave all or some of that risk on its books, or whether it wants to hedge externally against some or all of that risk. On the facts of the case, there was no external hedge that could be, as it were, traced to any relevant risk associated with the breach of contract. But the likely position, so the judge held at first instance, was that the pricing risk associated with the Total contract did find an equal and opposite pricing risk somewhere in Vista, and in effect, they cancelled each other out. So what was argued at trial? So Rhine argued that ultimately, what one has here is a situation in which one pricing risk has been internally offset, and the effect of that was to make good the loss on the physical trade. In other words, the gain generated by the equal and opposite hedge was to be applied to reduce the physical loss. They also said, if it was necessary to do so, that Vitol should in effect be treated as if being comprised of separate legal entities, with one portfolio of risks being a separate legal entity from another portfolio of risks, which then enabled them to make the argument that you needed to look at each group of risks independently of one another. Because, of course, if you were to look at it collectively, you would know that for every dollar lost by one portfolio, there would be a dollar gained by another. By contrast, Vitol argued that because these arrangements were internal, they necessarily could not, in fact, at least by themselves, affect the financial position of Vitol. This is not a situation in which a third party, in response to a particular event occurring, is putting money into Vitol. All that is happening is effectively Vitol is moving money from one pocket to another on a piece of paper. We also argued that even if you could somehow identify a gain, because the ultimate source of that gain was another physical trade which simply existed in the ordinary course of business on the books of Vitol, that would be regarded as a gain that was collateral to the breach, and applying the relatively recent Supreme Court guidance in the Swinson case would be regarded as legally irrelevant by virtue of being res inter alias acta, or collateral. The judge dealt with the external hedging position. It wasn't directly relevant to any issue he had to decide, but really anticipating the kind of arguments that Catherine would make, he considered it appropriate to consider what the position would be had it been an external, and was the fact that it was internal made a difference. And in essence, he analysed the cases that Chirag's taken us through. And what he concluded was that where a party externally hedges in consequence of a breach to mitigate, then that would be a benefit that would be brought into account. It would not be collateral. He then said that if profits are made as a result of a hedging transaction entered into before the breach, and which were not thereafter adjusted in the light of the breach, may be in a different position. But he said he did not need to consider that transaction, that type of transaction in this case. And the reason he said he did not need to do that is, on the facts of Rhine and Vitol, there was a pre-breach hedge. However, it was then subsequently varied in response to the breach. So just pausing there, one thing that is left open by this judgment is the position if you have a pre-breach external hedge, which is then not in any way varied or changed in response to the breach, do you take that into account? Not answered by the judge. So with that analysis, he then concluded that if the internal hedges had in fact been external, then they would have counted, they would have been brought into account, and the loss would have been reduced. So did it make a difference that they were in fact internal? As to which, no. The swaps couldn't be regarded as legally binding contracts. They did not, as a matter of fact, affect Vitol's profit or loss. They merely transferred the risk within Vitol across portfolios and did not make good any loss that had been suffered. I've put other quotes that make essentially the same point up on the slides. So the arguments were rejected, both of them. A, the factual argument that the loss had in fact been avoided, and secondly, the legal argument that these entities, portfolios, should be regarded as separate entities. So you could focus purely on the financial position of one portfolio. The judge also accepted the argument that even if there had been a gain, that gain would have been res inter alias acta, because the gain was ultimately derived from the performance of physical trades, which Vitol had happened to conclude in the course of its ordinary, normal operating business, and not referable in any way to the Total contract, still less the breach of contract. So they wouldn't have counted, even if they had generated a gain. And again, I put some more quotes up on the slide. So off we go to the Court of Appeal, permission granted by the trial judge. And shortly before appeal, Rhine Shipping repackaged its case and abandoned the analysis it advanced at trial. It now flipped the approach to damages. It said that what the court should have done was to compare the position as it was in the breach world, so the actual world, and the position Vitol would have been in had there been no breach. And as to that, it said that had there been no breach, Vitol would have had to have concluded a loss-making external hedge. And that avoided loss must be brought into account when assessing damages caused by the breach. So it was a different gain that Rhine Shipping were aiming at in front of the Court of Appeal. So previously it was the gain made in fact by reason of the performance of the internal swaps. Now it was the gain in the form of an avoided loss-making external hedge that would have been made had there been no breach. And one can see why, in the light of what the judge has said about external hedgings, they were keen to find a target which involved an external hedge, even if it was a counterfactual, non-existent one. Lord Justice Popwell, giving the main judgment, effectively approved, in the light of the jurisprudence Chirag's taken us through, the analysis that Simon Burt had taken of the cases up until that point and their application to external hedges, so approved of the analysis at first instance in that regard. He also said that had the case effectively not been abandoned that was argued at trial, he would have reached the same conclusions as the trial judge did. And in effect, therefore, what became of this appeal was not really, unfortunately, an appeal about hedging, but an appeal about when you can change your case in front of the Court of Appeal for the first time. So we had some general consideration of some well-known authorities which make reasonably obvious propositions, which resulted in the court concluding that the new argument was obviously fact-sensitive and Rhine neither had factual findings or sufficient evidence that it could point to as being incontrovertible to advance the case that it wished to advance on appeal. So ultimately the appeal failed because it wasn't open to Rhine Shipping to put their case in this new way. But in that way that judges like to do, and having heard argument and having obviously thought very hard about it, Lord Justice Popwell did wish to dip his toe into what the position might have been in another case with such an analysis. So he said, first of all, that the avoided external hedge is not a mitigation argument. And the reason that it's not a mitigation argument is it's obviously not focusing on something in fact done in response to a breach. It's focusing on something that didn't happen because of the breach or by reason of the absence of the breach. So whatever the right analysis to another case which may have similar facts is, it's not going to be mitigation. So what is it then? It's the avoided loss argument, which then immediately brings into account the res inter alias acta argument once again. Is the avoided loss a collateral benefit, or is it something that is caused by the breach? As to which, and referring to the New Flamenco case, which Lord Justice Popwell had dealt with at first instance, made clear that in this context, it's not a but-for causation test. So the mere fact that Rhine Shipping might have been able to prove that but for the breach, an external loss-making hedge would not have been made, will not be enough necessarily in this world to prove that the breach caused that avoided loss. So what the judge said is that it's not going to be a but-for test in this situation, and causation issues are not straightforward. Notwithstanding that, the judge did express a very preliminary view that he felt that the collateral benefit principle, so the res inter alias acta argument, would place formidable difficulties in the way of Rhine's new argument succeeding. But he said that he would prefer not to express a concluded view for the simple reason that there were not relevant factual findings before him. So whilst no doubt we'll kind of chew over this all together in due course, I think just very briefly, the position after this case is that the factual findings of the first instance judgment having been approved by the Court of Appeal, if one tries to argue a case based on that argument, you know you're going to lose. If you try and run an argument like Rhine Shipping were unable to do, you're in the game, but if you get in front of Lord Justice Popwell, you might be struggling. But that one's still up for grabs. So thank you for listening, and I'm going to pass you now back to Catherine, who's going to tell me that that was all a load of rubbish.
And I'm going to tell you that the industry thinks it's a load of rubbish, yes. Or at least it's not what they believe is the right way of conducting their business. So I'm going to look at it from the trader's perspective, and I'm not here to tell you the law. You all know much better than I do, but my thinking is that the legal principle of damages is essentially to put the claimant back into the position they would have been had the contract been performed in accordance with its terms. Now, if you recall what I talked about at the beginning, what hedging is all about, it's to lock in the price, it's to lock in their margin. So effectively, by hedging, whether it's internal or external, the claimant has actually done this for themselves. So therefore, in my opinion, and I'll come on to what the industry thinks about it and what they're doing about it, the claim should be the difference between the physical price change and the hedge outcome. And that can work either way. As we've seen with the Choil case, here there was actually no loss on the physical, but there was a loss on the hedge. Or it may be that there's a loss on the physical and a gain on the hedge. Either way, it should be taken into account, whether it's external with a third party or internal with different trading books within the same company. It should be treated as a benefit or loss. Because without that, any claimant will always claim when the physical market goes against them, and the respondent is going to have to pay out. But they will know in reality that the claimant didn't suffer that loss. So let's just look at the charterer's view of this pre-Rhine. So if there was a vessel delay, the trader will automatically hedge the change in the price risk once they're aware of that delay as best they can. That locks in their expected return, as if the delay hadn't occurred. There may be some margin, as we saw in the Rhine shipping case, that actually the net loss was only 800,000 because the imperfection of the hedging. But it's less than the physical loss. So on a purchase, this is pre-Rhine, if the delay leads to a lower price after accounting for the hedges, then the trader needs to pay for the trader needs to pay for the cargo being loaded. They're unlikely to make a claim, but if it leads to a higher price after taking them both into account, they will make a claim. And the loss for the charterer could come about by means of the loss on the physical, or a greater loss on the hedge than the gain, as we saw with Choil. Post-Rhine, this now presents, as I explained before, with a larger trader, something that is not going to be enjoyed by the smaller trader. They can book their hedges, that's what they refer to, and they will automatically hedge, but they don't have to have that taken into account. Which means that if the delay leads to a higher physical price that they must pay for the cargo, then the charterer will always make a claim against the ship owner for that absolute physical price difference, irrespective of any of the hedging gains. But the small trader can't do that because they're at risk of having their hedging losses or gains taken into account. I'm going to skip through some of these. The big disadvantage that I see in this is the ship owner, because the ship owner post-Rhine is now at a severe disadvantage. Ship owners are well aware that most traders hedge, and they may suspect that the physical loss is not as great when you take into account the hedge, but how do they prove that? They don't have access to it. And in many of the cases that we're involved with, sadly, we don't get instructed until the pleadings have happened, discovery has been asked for, witness statements have been taken, and then suddenly they ring us up and say, oh, would you help us on this case? And we'll say, yeah, well, have you thought about hedging, because this is a market movement claim? And, oh, no, well, we can't really include that now because it's not in the pleadings. Very difficult. So we obviously prefer to be instructed earlier on. And if we are instructed earlier on, we can ask the right questions of the claimant, the trader, to say things like, can you provide your risk management program? That will say whether or not they're allowed to have speculative positions. Can you provide us with your mark-to-market, your daily mark-to-market? Can you provide us with, and we will go and we can ask these things. And ultimately, they will have to reveal what they do. And we have had a number of cases, both pre and post Rhine, where the traders have actually given us this information and admitted that they were hedging. And I was in a case very recently, like in the last 2 weeks, where a very large trading house said, we know what the decision in Rhine is, but we don't think it's fair, and we are going to admit to $2.5 million worth of hedging gains that we made, and we are going to allow for that in our claim. Now, I think that's very magnanimous of them, very generous of them, but they were adamant about this. But maybe it isn't quite as magnanimous as it may seem, because it may work one way with the swings, but another way on the roundabouts. So the traders want to be able to claim if their hedging losses are greater than their physical. So as far as the industry are concerned, I'm afraid they don't agree with the decision that was made in Rhine Oil. And in particular, they don't agree with this notional trade argument. The notional trade argument is that these are not real trades. But I go back to what was attempted to be claimed in the appeal, which was unsuccessful for nothing to do with the facts, but to do with whether or not they could be allowed to change their case. And I was interested to hear your point, and we're now starting to get into discussion, but I was interested to hear your point, Paul, about that there had to be some sort of a change to it. And it's interesting, I think we can discuss about that, but also this point about whether or not you can accept something that didn't happen, in other words, the saving that they made. Because the other way of thinking about it is that actually they made a conscious decision to match that with the existing risk, rather than matching it with an external trade. But we're getting more into discussion now. So that is essentially what the industry is saying now. So I'm going to pass this on to Robert.
Ooh. Subject to questions and answers, bring the proceedings to a close.
But it definitely will not be anything that you could call a final award. This is about trying to think about what the law ought to be, as distinct from what it is. And Catherine asked me when we went through this beforehand whether this was something I really believed or something I was just putting up to provoke argument. And the answer is it's somewhere in between. This is something that I'd like to give a run for its money. And the thought is, English law, certainly in the fields of commodities and shipping, is basically an expert. It has a market. If people don't like English law, then they can find another system. Perhaps the question should be whether if the Singapore courts, which are policy-driven, went in for the simple Sale of Goods Act rules and disallowed hedging, whether that would bring more contracts under Singapore law rather than English law. The thought is, this is an added layer of complexity, that damages for simple breaches of commodity and shipping contracts, I'm reading what I wrote, have to depend on a careful investigation of the claimant's hedging arrangements, where if we go down this road, it'll get increasingly sophisticated. In the Choil case, it was presented very simply by the claimant. They simply claimed, on the one hand, the premium over dated Brent that they would have received under their original sale contract, which they lost because the cargo was contaminated, as against the discount to dated Brent that they received on their substitute contract for selling the contaminated cargo. They weren't interested. The fact was it was different dates. Dated Brent had gone up a shed load, but as far as they were concerned, all they were interested in was their premium and the discount that they suffered. Dated Brent could go up and down like a yo-yo, but that was irrelevant to the way their business worked, because they were treating it as if they'd hedged 100%. Sorry, I should say 100% effectively. Now, as Catherine has told us, in the real world, hedges are only 80 or 90% effective because Choil had the actuals, in the words of the jargon, was long on naphtha, but what it had to do to compensate was to sell paper barrels of Brent crude, and naphtha's not Brent crude, so it's not an exact hedge. Suppose you wanted a simple rule. There are two possible simple rules you might take. One is, for traders, everybody is deemed to have hedged with 100% efficiency. We're not going to ask whether they did it internally or externally. We're not going to ask how efficiently it worked. The other one is the simple Sale of Goods Act rule and whatever. We disregard the lot, like insurance proceeds. We keep it simple. Now, I was wrong in what I wrote there. The hint by Popplewell is actually a lot more complicated, and it's about internal hedges. And as Paul said, he was perfectly happy with external hedges, which are real contracts, being taken into account. But still, disregarding is the natural reading, I'd suggest, of what you get in the Sale of Goods Act. Look at those words, and naturally. And what you get in the Hague-Visby rules. Look at the second paragraph. It's not talking about people's losses as a result of things that they've done. So if you take the other simple rule, everybody's hedged 100%, that probably fits the traders. How are we going to work it with charter parties? Most ship operators probably hedge movements in the price of bunkers. How many ship owners hedge their time charter rates by using forward freight agreements? I don't think there's any general rule either way. And I'm looking at the difficulty of the solicitor who says to an owner of a certain nationality, which will remain nameless, do you hedge? No, the registered owners don't hedge. There's another company down the corridor which happens to do opposite transactions in the paper market. But that's nothing to do with the registered owners, so it doesn't get taken into account. By the time you've fought your way through that, the costs will be enormous. And also, I think, the consequence of deeming that everyone is hedging in the trading market, but in the shipping market they're not, is you can't pass damages along the line because the damages will be different according to who's deemed to have hedged and who hasn't. On the other hand, and I'm coming to the end, there are two problems for the simple rule of disregarding hedging. The first enters in by way of the Choil case, where, as Chirag explained, Choil didn't hedge before the breach. They took out the hedge simply because they were left with this parcel of naphtha on their hands and wanted to protect themselves against downward movements in the price of naphtha while they got this stuff on their hands. So that fits into the rules on mitigation. And then you get what I hadn't spotted before Chirag provided it to me, the Narmada spirit, where they don't take out the hedge the first time after the breach. What happens is they have the hedges beforehand, but then you need to do things with the hedges. I'll try not to say rolling because I'm not quite sure I understand what rolling is. But they have to do things with the hedges because of the breach. So that counts as mitigation, though it's mitigation not simply because of the physical transaction, but as a result of the pre-existing hedges you have. So once that's got in, how do you stop the whole thing from getting in? Well, it depends whether you agree with Catherine. If you agree with Catherine that what Vitol did is to count as the same as external hedging. I defy you to get that in by way of mitigation. I think that the Rhine shipping judgments have more or less blocked that completely. And what you're going to have to do instead is to say, it's nothing to do with mitigation. The trouble with Rhine shipping is they tried to get it into the terms of mitigation because that was what the pre-existing cases were, and they were trying to use the pre-existing cases as a sort of legal battering ram. In reality, you just need to stand back and look at the reality of the situation. That's, I think, what happened in the judgment in another of the previous cases called Glencore and Transworld. And it's, I think, what people's sense of justice would say about the Vitol case. It may not fit into any kind of mitigation, but the reality of the situation is that Vitol had carefully arranged their business so that whatever happened to the price of Brent crude or whatever other base there was as the pricing for their various contracts, they were not going to be affected by that because, except to a very limited extent where they decided to take a punt centrally, they'd sorted their business so that all the movements in the base prices cancelled each other out. And the real problem for me with the nice simple rule that I would have preferred to start off with is it offends my sense of justice. As Catherine said, Vitol recovered for a loss that in the real world they hadn't actually suffered.
Thank you very much. So now I think we have an opportunity for some questions, if there are any, from either our physical audience or our Zoom audience.
And I should say, sorry, if it is physical, we need a microphone to give to you, not for amplification, but purely so the virtual can hear. So
I see that Sir Jeremy has got his hand up already. So let's, and then there's a hand at the back, which we'll come to.
Shall I speak without the microphone and hope people can hear?
No, it's coming.
I think it's best to wait because we've got a remote audience.
Thank you very much. This really arises out of what Paul was saying on the Vitol case. It's one thing if you can identify a counterpart transaction, but with a big oil trader, and I've come across this several times, they have a treasury function in the middle that takes all their transactions and then works out what they're going to do, both in the real world and in the notional derivative world. And I don't see quite then, when you look at that, how you can attribute anything at all to either as a form of mitigation or in fact in reality, because they've done it all before, as a consequence of the breach. How do you pick it up? I think in the Vitol case, you suggested that they notionally had a counterpart trader that you could have looked at. But in the cases I've seen, that hasn't been the case. It's just been a very broad spectrum of activity that's been taken into account in all directions.
I think, yeah, absolutely. I think
it's like a bookie.
It's a so-called
in every single case. Doesn't matter what happens in the world, we're going to make a profit because we've hedged our odds.
Well, I think it's certainly the case that informed Lord Justice Popwell's view, cautiously obiter, about the counterfactual external book hedge. The judgment refers to it as being a book hedge. So what he was envisaging was the recipe of multiple pricing risks being, some analogy, generating as its product an external hedge, which is made up of everything that is contributing to it. So to be able to say that a breach of contract over there, which caused a pricing risk over there, which we managed to semi-offset over here and then over there, caused anything to come out of it on its own, is obviously problematic. And I think that's certainly what was informing his concern about the external hedge. Obviously, internally, if you wanted to just look at two pricing risks together and just focus on those, you might be able to say more straightforwardly that they've cancelled each other out. But then the question is, does that make any difference to Vitol's position? And that was the argument, obviously, at first instance that failed.
Why does that work on an internal basis? I don't see how it does at all. Because again, you're going to have an amalgam of trades in all directions.
Yes.
And you're just making sure a whole lot come out with your head, one way or the other. You can't identify anything. Individually, you could say offsets that particular loss.
Absolutely, and I think I would slightly take issue with Robert saying that Vitol had arranged their business in a particular way. Well, they hadn't. They did their business, and having done their business, they saw where that left them globally, and having done that, they decided what external position to take, if any. So, anyway, I'm sure others will have comments.
Does anyone else want to comment on Jeremy's question before we go to another question?
Might I just comment on it?
Surely.
Yes. Vitol did rearrange their business in as much as if that breach had not occurred, they wouldn't have been having to match up the rolling that they had to do as a result of the breach. That's the point there. The trouble is, and I agree with you, Jeremy, you can't pinpoint which are the matching deals. I would point out that actually with external swaps and futures done through an exchange, you don't know who your counterparties are there either. You do it with the exchange, but it is easier to see what you've actually done. But I would go back to my point that it seems inequitable that a small trader can be allowed to offset their losses or indeed have to offset their gains just because they hedge externally, but a large trader doesn't. I mean, if you take that to its ridiculous extreme, every ship owner is going to say to their charterer, well, excuse me, do you hedge on an internal or external basis? Because if it's an internal basis, then I'll give you this rate because I'm running a risk that I'm going to be liable for 3 million rather than the loss you've actually made. Seriously, this is what some of the ship owners are saying to me.
But they can bring a claim for the loss on their external hedge, though, which an internal system would not allow you to do.
They can, absolutely. But equally, the trader that has an internal system may well not like this decision. And the one that I was talking about, although in this particular case, they allowed for the gain, I'm sure that's behind it. They wanted to be able to claim for their loss, which is why they don't like the decision in Rhine. Yeah.
Shall we go to another question?
Yes. No, there's no...
Audience participation.
Yes.
Stand up, please.
I was just wondering if there's any indication as to whether the Court of Appeal decision will be appealed on, and if not yet, do you envisage that it will be?
It's unappealable simply because, as I indicated, in truth, it's not a hedging case. It's a case about in what circumstances can an appellant change the basis upon which they advance an appeal. So it can't be appealed. It hasn't been appealed, and it won't be appealed. So we're left with some tidbits that are essentially operative, I'd say.
Is there another question?
Yes.
Yes, here in the third row.
I think this is a question for Paul. I'm wondering, is there an asymmetry in Justice Popplewell's saying that the hedging losses gains would be collateral raising to alias acta, and yet in other cases like in Armada, it's been held that hedging losses are not collateral. Can you explain, should it not be the case that either all hedging losses are collateral or all hedging losses are not collateral?
Well, I think that's Robert's thesis, and I have some sympathy with that. I think the distinction, between the Namada Spirit and the Vitol cases, again, it comes back to the external-internal, because with the external hedge, I've got a pricing risk with a contract, and I go into the market and I buy a swap directly with someone for that pricing risk. Even if you get an external book hedge derived from internal transactions, you're not going to have that. What you're going to be having is an external hedge, which is covering the price risk associated with many, many contracts, which have then been treated in that internal way. So the reason that the collateral res inter alias acta argument was found to work in the internal situation is that, but looking at the argument on first instance also was because in the external world, the money is coming from a third party directly. In the internal world, because of a transaction which you've entered into specifically for the purpose of managing the pricing risk. If the internal transactions are said to create gains, they're said to create gains because somewhere over there, Vitol happens to have performed a contract on equal and opposite terms, which has generated revenue, which it would keep for itself ordinarily. But if you say that that revenue over there essentially has offset the loss over here, then Vitol is directing revenue away from itself to the party in breach. And the point is that the gain there is derived from something entirely independent of the breach. It's derived from Vitol performing contracts which just so happen to be on equal and opposite terms. They're not concluded for the purposes of creating an internal swap. So it was a very long and slightly gibberish answer, but hopefully some of it made sense.
Can I have a go a moment? I think part of the trouble is, certainly to me, and that may be my fault, I don't find the judgment of Lord Justice Popplewell easy reading. But what he does all the way through, as it turns out, in paragraph 12 he says, if these were real external contracts, then they wouldn't be collateral. And then at the end of the judgment he says, but these internal hedges, so-called, are collateral because, as Paul was saying, they are the products of contracts which were entered into not in any way in connection with this contract that's been breached, but simply they're all the other contracts that Vitol entered into in its ordinary course of business. Have I got that right?
Yeah, there's one strand, but there's a complication, but I'm not going to... Yes, but absolutely. What you said is completely right. Absolutely.
I would really ask a second question, which is the interim answer for all shipowners to exclude any liability in respect of price risk? So this gets sorted out.
It's very interesting because one way of them doing that is to do what was one way that was argued in the Chol case, which is looking at the difference between the differential to the market price. So, and that's one way of taking out market risk. And in many of the cases that we get involved with which settle, we do exactly that. They don't really want to get into all the details of the hedging, but the parties are content to say the cargo was originally sold at +4, it was eventually sold at -7, so the loss is $11. And that strips out the market risk.
All right, any other questions?
I just wanted to ask this in connection with what's just been discussed. I've certainly seen contracts, and I can't quite recall which context, where there's been a specific exclusion of hedging and liability in respect of hedging, so that it's taken out of the equation, which makes life much simpler for the judges and arbitrators.
That was the case. In fact, they put it back in again. It was taken out of the BP terms and conditions, and they put it back in again, I think, because they realised that the swings and roundabouts, you know, they wanted to have the opportunity on both sides. Sorry, were you going to add something as well, Stuart?
I was just going to, first of all, a big caveat. I've not had a chance to read the judgment of the Court of Appeal, but I'd make a number of points. Firstly, I wish judges wouldn't, in unappealable cases, give such, dicta and, some cause confusion. Secondly,
Being helpful.
well, I think he is to the lawyers amongst us, because we'll have lots of different theories as to what the law is, and we'll be able to fight it. Secondly, it seems to me to be contrary to the fundamental compensatory principle if you look at it in the broad as Robert was doing, and it also seems to me to miss the wood for the trees by saying we need to chase everything through. If you know as a fact, and I don't know if this was the case, that but for in the no breach situation, they would have, if that transaction hadn't happened, there would have been a different hedge. So that transaction has incurred a gain. And that's why they hedge internally. But also I see the force in Catherine's thing is, why do you treat big traders differently from small traders? And it can work in both ways.
Any other questions? Well, if no other questions, and before I call on Paul Eddings to bring our proceedings to a close, will you grant me a minute or two to, I don't want to say to sum up, but to make a few remarks. This is a very, very interesting and difficult field, and although Catherine has had decades of experience in it, I think to the courts it's only a decade or two old, and essentially we are still at first instance jurisprudence, because the Court of Appeal case subject to the odd dicta here and there, turned on the point of whether you could have a new argument at the Court of Appeal. And as Paul has explained, on that ground, it's not going to go to the Supreme Court. So we're in a new area. And it rather reminds me of that line about angels and fools. And I'm certainly no angel, and I would like to think that I'm not a fool. But I'd hazard a few comments. First of all, this is a very interesting case of common law jurisprudence taking a new problem and chewing at it in various different situations and seeing how we go. Ultimately, this problem is going to be settled, first of all, by a Court of Appeal case which has to decide issues, but ultimately in the Supreme Court. But I hope not too soon, because you really need a bit of thinking before it goes up to the grand masters and mistresses. The other comment I would make is we should really seek a simple rule. Now, in sale of goods, if you wanted to pursue the compensatory principle, which is of course a fundamental rule, by looking to see what each seller or buyer is doing, selling and buying and rebuying and selling and so forth, you would get into similar kinds of complications. But by and large, there are exceptions, by and large, our jurisprudence over the centuries has sought a simple rule, which is to say, you concentrate on this case and how the market was different at the time of breach from the time of contract. And I think there's wisdom in that, and I think we will need to find a simple rule for the new problem of hedging. And Robert has suggested possibilities of simple rules. I'm not sure how you're going to bring it into line with principle, which is what the Supreme Court will have to do. I suppose you might say, in certain trades at any rate, that hedging had become so standard that the trade and the hedge were to be regarded as a single contract, and therefore you concentrated on the two together. If you think of the similar problem which arose in insurance, not something you mentioned, Robert, but it was in your slides, so I thank you for the thought. There you have the insured fully indemnified, let's say, by his insurer. He suffered no loss at all, right? But the courts did not allow the defendant to say that against the insured. And the rule became that it's res inter alios acta. Although, of course, insurance has become pretty standard, and possibly in certain trades, like carrying goods on ships, absolutely standard. But the rule is it's res inter alios acta. How do you deal with that? You deal with that by the separate mystery of subrogation, which gives to the insurer, but note, in the name of the insured, who has suffered in truth no loss at all, yes, a right to claim against the wrongdoer. Why did these rules develop? Because other jurisdictions have dealt with the problem of insurance in somewhat different terms. Some say that there's an assignment and the insurer sues in his name and not in the insured's name. Well, at any rate, these rules were developed in order to promote the good British industry of insurance, you might say. I don't know how we're going to deal with hedging, but I would hope that we will keep our rules simple. And with that, I'll call on Paul Eddings to bring our proceedings to a close.
Thank you very much, Sir Bernard. Okay, so putting my LSLC hat on, I just want to say some thank yous. I don't want to go over the ground again, but thank you to Quadrant for hosting this. Thank you very much to the panel. It's been a fantastic panel session. I'm sure you'll all agree with that. It's been quite a paradigm, actually. We've had an expert here to set the scene, Chirag to say what the law was before the Rhine case, Paul to tell us all about the workings of that particular case, and then some typically incisive comments from Robert here, looking at it not just on the facts of that case, but some real food for thought, for example, in relation to ship owners hedging. And then wrapping it up, Sir Bernard, thank you very much. So thank you very much to the panel and to the chair for your concluding remarks. Without wanting to take you away from your keenness, obviously, to get away to your firework parties after this, can I just also make a plug for a couple of things. We've got coming up on the 20th of this month, it's going to be in the early morning because we've got a webinar with in conjunction with the Singapore Chamber of Maritime Arbitration. And that's going to be reimagining bills of lading for the 21st century. So I hope you can come online for that. The second thing is for those of you who are lucky enough to be under 39, to remind you that we have a competition with some prize money, and details can be found about that. We're inviting people to put in essays. And the last one, it's very much at the beginning, but spreading the word. And I know it's got out amongst a lot of the supporters of the LSLC, but next year is our 30th anniversary, and we're going to have a dinner in June. So I just want to float that out there so that you're aware of that. And hopefully people are already taking tables. I know Quadrant have, for example. So look out for that, and we hope that next year we will definitely see you for the celebrations in June. So that's all I wanted to say. Thank you very much to the panel, and I'm sure you'd like to put your hands together to join me in thanking them.